And court does call the case of the people versus Shonda Jefferson.
This case opens with a calm courtroom announcement, but don't let that quiet tone fool you. What unfolds here becomes one of the most revealing looks into protocol, responsibility, and judgment inside a school transportation system. Right from the start, Judge Simpson is preparing to evaluate not just what happened, but why it happened, and whether a school bus aide crossed a critical line in handling a vulnerable child. Before we dig into the testimony, keep this in mind. Child safety laws don't only punish visible injury, they also address risk, and that distinction becomes the backbone of this entire case. As the attorneys position themselves, notice how the defense immediately tries to set a sympathetic frame. A grandmother, decades of experience, a clean record. This is an attempt to anchor the judge emotionally before the facts land. Meanwhile, the prosecution's silence during opening signals a strategic move. They believe the video and the witness statements will speak loudly on their own. You're going to see how standard procedures, IEP requirements, and restraint rules become the battlefield. And the question that will echo throughout this trial is simple, but heavy. Did her actions create an unreasonable risk of harm? As we move through each witness, look for contradictions, missing protocols, and the subtle ways each detail chips away at the defense's argument. This is where the real tension begins.
Caitlin Kirby on behalf of the people.
Sylvana Reed, Assistant Public Defender with and on behalf of Ms. Jefferson. Jefferson, could you state your name for the record?
Good morning, Shonda Jefferson.
And Your Honor, this is the date and time set for a bench trial. The people are ready to proceed, and I believe that that's what the defense wants to do as well.
All right, very good. All right, opening statements.
I would waive opening, Your Honor.
Any objection to the people waiving opening statements?
No objection.
All right, would you like to give an opening statement or reserve?
I will. I'll be brief. I just
All right.
wanted to share with the court that Ms. Jefferson is a mother, a grandmother, and someone who's been working with children in the school system since 1998. She's someone who cares deeply about children and hopes to continue being able to work with children for the rest of her career. She has no criminal history, has never had any trouble before this case throughout her more than 20 years of career work. I hope that you will see today that she never intended to harm anybody, and is very saddened by the fact that the situation has resulted in any negative outcomes for it.
The defense is doing exactly what any seasoned courtroom observer expects, building credibility before addressing the incident itself. By emphasizing her background, 20-plus years working with children, a grandmother, a clean record, the attorney is crafting the narrative of a trusted caregiver caught in a misunderstood situation. This tactic matters because Michigan's child abuse statutes don't require malicious intent. They require actions that create unreasonable risk, even if the person meant well. This opening is strategically emotional rather than procedural. The defense wants Judge Simpson to view the defendant not as someone careless or reckless, but as someone who simply made a mistake under pressure. But here's the tension. Good intentions don't override policy. And when those policies involve restraints, IEP requirements, and safety equipment, judges rarely let "I didn't mean harm" outweigh what actually happened. Audience question: do you think a clean record should influence how strictly the judge interprets protocol violations? Or should child safety standards override sympathy every time?
All right, very good. And I'll pardon you for keeping your seat and addressing the court. You may call your first witness.
Your Honor, the people would call Sherry Henry on.
And please come forward to be sworn.
Raise your right hand. Swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Want to take your seat, state your first and last name and spell it for the record.
Charlotte Henry, C-H-E-R-Y-L, last name Henry, H-E-N-R-I-O-N.
All right, you may inquire.
Thank you. Ms. Henryan, where are you employed?
Durham School Services,
And what is your job there?
safety supervisor.
And what does that entail?
A lot of things, monitoring the driver, keeping everybody in compliance, hiring new drivers, training drivers,
And when you say drivers, what kind of drivers?
school bus drivers.
And how long have you been employed there?
With Durham since 2008, August of 2016.
And are you familiar with a Roshana Jefferson? And do you see her in the courtroom today? Okay, and can you identify something that she is wearing, please?
You sure?
Okay, and let the record reflect that this witness identified the defendant as Rashonda Jefferson.
Without objection, record shall so reflect.
Thank you. And how do you know her?
She was one of our monitors.
And what does that mean?
She was a bus aide taking care of children on the bus.
And what is their job duties?
Make sure that the kids are seated, stay safe, tend to, if they need anything on the bus, help the driver.
And are they given certain instructions on how to care for the children or monitor the children? And where are those written?
Usually, there's a routing department will tell them, we give them special needs training. That's a classroom set.
This testimony is critical. Ms. Henry is laying out the structural backbone of how transportation staff are trained and what protocols they're expected to follow. The prosecution is using her to establish industry standard procedure, meaning the moment those procedures are violated, liability becomes crystal clear. Her explanation of star seats, harness systems, and the immediate restraint rules is important because it shows these aren't suggestions. They're requirements, created to protect vulnerable students. And when she confirms that any child requiring a restraint must be secured as soon as they enter the bus, she's drawing a line the defendant is later accused of crossing. This witness also clarifies something subtle but huge. Aides and drivers don't have IEP access, only route sheets. That means the defense can't argue the defendant never saw the IEP. The law expects staff to follow the instructions they do receive. Key point for viewers: when protocols exist specifically to prevent unpredictable behavior, breaking those protocols, especially with special needs students, creates automatic risk. Would you feel comfortable if school staff used discretion to restrain a child mid-ride without documentation? Why or why not?
And do they have any other information given to them when a student is on the bus?
Yeah, if there's any information, the routing department will get that with them, or it'll be on the route sheets.
Okay, and so what kind of information would you give for a specific child or the aide?
Anything that they would need, if they needed to be sat by themselves, if they needed to be in the front, in the back, if they have allergies, there's all kinds of stuff.
Okay, and does this sheet also include how you would restrain a child or how you would handle a child getting upset on the bus?
It would say on the route sheet whether they had to be in a star seat or a harness. It would have that next to their name and their stop.
Okay, and what is a star seat?
It's a 5-point seat that they go in that would keep them restrained. It keeps them in their seat.
Okay, and can you explain how it keeps them in their seat?
It's hooked to the back of the seat. Harnesses would come around them, or the star seats, they're buckled in, similar to a car seat.
Here the prosecution is tightening the screws by making the star seat system unmistakably clear. When Ms. Henry describes how these seats restrain the child, the judge is getting a technical picture of why unauthorized restraint is such a serious violation. A star seat isn't just a belt. It's a full 5-point restraint system, comparable to what you'd find in certified child safety seats. That level of physical confinement requires explicit authorization. By establishing that these seats are installed ahead of time for specific children and must be used immediately upon boarding, the prosecution dismantles any defense argument suggesting spontaneous restraint was acceptable. This part of the testimony also highlights why parents rely so heavily on school systems to follow IEP instructions. The restraint process is rigid for a reason. Putting a child in mid-ride without proper cause can escalate fear, trigger behavioral spirals, or worse, cause injury. Transition for viewers. We're about to see how this clarity becomes the foundation for Judge Simpson's legal reasoning later.
And is it typical for that to be written clearly next to a child's name?
Yes.
And if a child does need that kind of restraint, when would that restraint come into place?
When the student rides on the bus and when the driver and monitor is notified.
Okay, and so would a child getting on the bus be immediately put in a star restraint if that's what they needed?
Yes, if it's on their IEP, then they would immediately be put in it.
And what is an IEP?
It's an individualized education plan.
And so if it's on their IEP that they use a star restraint, when they first get on the bus, they would immediately be put in a star restraint. Is there any situation where a child would just be put in a star restraint in the middle of a bus ride?
No, no, they have to be secured right when they get on the bus.
This is a decisive moment. The prosecution has now established that restraining a child mid-ride is not simply improper. It is categorically outside policy. When Ms. Henry confirms that protocol demands immediate restraint upon boarding only if the child requires it, she simultaneously discredits any claim that the defendant's actions were improvisation allowed under policy. This also strengthens the judge's eventual finding. The issue isn't whether the child was out of control, but whether the defendant had any legal or procedural authority to strap him in during the route. This testimony also reveals the double burden school transportation staff carry, maintaining order while respecting strict standards. The defendant's decision, whether out of frustration or misjudgment, crossed that line. And in child welfare cases, risk is enough. Actual injury isn't required. Audience reflection question: should school staff ever be allowed to make mid-ride restraint decisions during emergencies, or is that too dangerous to permit?
And is it normal for if it's written on the IEP to have a star restraint? Is the star restraint already on the seat, or is it put on the seat before the child gets on the bus?
No, it would already be on the seat.
And is it your job to monitor if children are being put in a restraint or how they are put in the bus?
No, not really. We give them the training. If they have problems, they would come to myself or a trainer just to make sure that they're being hooked up the right way.
And are you familiar with December 14th of 2021? Are you familiar with that date?
Yes.
And why are you familiar with that date?
That was the date, I believe, that the district wanted us to watch a video.
Okay, and what kind of video was that?
It was a video of a driver and monitor transporting a student that was being put into a restraint.
And were they being put into the restraint when they were getting on the bus, or?
No, it was during the bus ride.
And like you testified earlier, that's not typical to you? And what else did you see on the video?
I remember it's been a while since I've seen the video. I remember the driver going to the back of the bus, bringing the child up front to the seat, and then Roshonda took over, trying to get the child into a restraint.
And do you know, after looking at this video and reviewing it, do you know where the bus was at this time? If it was in what city or township it was in?
I do not remember.
Okay.
I don't remember the stop location.
And do you know what county it was in?
Washington, I believe.
And why were you asked to watch this video? Do you know?
The school district had called over and spoke with Charlie Bug, our operations supervisor, and wanted to review the video because of a complaint that they had. But
This section reveals the origin of the case, a troubling bus video that triggered administrative red flags. Notice how Ms. Henry states they were told to review the footage without being given a complaint. That usually indicates the footage itself is alarming enough that higher-ups wanted internal confirmation before escalating the matter. This is standard in child safety investigations. Administrators must determine whether what they're seeing is a training issue, misconduct, or an outright violation requiring legal action. Her testimony also shows that multiple layers of authority reviewed the video. This matters because it establishes credibility. The court isn't acting on one person's interpretation. It's acting on consistent observations across supervisory levels. The prosecution is building a chain of reliability: video, supervisor review, district involvement, legal escalation. This chain makes it harder for the defense to claim misunderstanding or misinterpretation.
And are you familiar with a Jay Swookie?
that was a student that was being put into terms.
And did you see his IEP?
No, I didn't.
And while at the time that you were watching the video for the complaint, do you recall what the actual complaint was?
No, we weren't told.
Okay, and so you were just told to watch the video is what you stated?
Charlie Bug was told to pull the video and to look at a couple dates, but they didn't tell him why. So he watched it, and then I believe he sent, no, Liz Margolis came down to watch the video.
And at that time was when you were watching the video as well?
Yes.
And is it standard for all the aides and all the drivers to know the IEPs of each and every student on the bus?
No, they don't have access to the IEPs. The only thing they would have access to is whatever would be on the route sheet or what they were told.
And has there ever been a circumstance to your knowledge where they were told something different than was on the route sheet?
That I can't recall.
And how many children are usually on a bus?
That could depend. A special needs bus, there could be one, there could be 5, 6. If they're on a larger bus, there could be more.
Okay. And Ms. Weidling, I'm gonna pull something up on my laptop.
And while you do that, I just want to make sure I'm understanding something. The star seat, is there going to be a star seat on every bus?
No.
Okay, so how does, well, let me ask it this way, I'm sorry. If the star seat is not on every bus, what has to happen for the star seat to be there in the first place?
Judge Simpson is doing something powerful here, teasing out the logistics to determine whether the defendant had access to proper equipment and whether she used it appropriately. When he probes how star seats get onto buses, he's identifying procedural responsibility, who installs them, when they're placed, and how diligently staff follow documentation. This line of questioning also signals that he's already navigating the heart of the case. Was there any legitimate procedural basis for restraining the child mid-ride? If not, the defendant's decision wasn't a misapplied policy, it was a breach of duty. You can almost feel the judge narrowing in on whether this was negligence, misunderstanding, or willful disregard. And that distinction determines guilt. This moment marks the turning point where Judge Simpson transitions from fact-finding to legal evaluation. The final ruling is beginning to take shape in real time.
There has to be a student that rides that bus that it's in their IEPs that it says they need a star seat.
Got it. And so to your knowledge, on this bus, on this occasion, was there a student that should have or may have had to have a star seat?
On that route,
Yeah.
I'm not sure.
Okay,
Could have been on a route.
gotcha. Okay, I get it. So if the bus then goes to a second route, then the star seat may be on there during the travel on the first route because it's going to be needed for the second.
Correct.
Got it. Great. Just as you do that, I now have my defendant back.
Well, we can pause if you want.
Yes, let's pause this for a moment. Let me also ask, this video, and I don't mind seeing it because I would have to see it, but we are broadcasting, and I want to make sure that, I don't know if there's the face of the child.
You can't really make out his face.
Good enough.
The
Good enough.
quality is not great.
All right. Okay, I'll briefly pause on this matter. You ready? We are then back on the record in the case of the People versus Jefferson.
And do you recognize, can you see the screen on your screen in front of you?
Hold on one moment. The individual that may not be the subject of this case, but is that a minor in the very front part of that?
Yeah.
The judge's caution about showing the child's face demonstrates ethical sensitivity, a reminder that courtroom transparency has limits, especially involving minors. Even though the footage is central to the case, broadcasting identifiable images could violate privacy laws. What's important here is the judge's framing. He is already contextualizing what he saw in the video, and he will soon articulate how the defendant's actions cross procedural boundaries. This moment also creates emotional grounding for the audience. We're not talking about abstract policy, but a real child whose comfort and safety depend on adults following rules. This brief pause shows how seriously the court treats the handling of vulnerable individuals, something that will echo powerfully later when Judge Simpson explains his reasoning for the conviction.
14 Judicial Court, County, Washington, State of Michigan.
You may be seated. We're back on the record in the case of People versus Shonda Jefferson. In this matter, the court has heard this case, and really the issue becomes the issue of posing or causing an unreasonable risk of harm or physical injury to a child. It isn't really the issue of whether or not the child was injured or anything along those lines. Was something done that posed an unreasonable risk of harm to the child? As I was thinking back through the video, a number of things occurred. And as the court was considering its decision, one thing that I realized is, I think in dealing with children is I'm listening to the protocols. The reality is you can have all protocols in place that you want. But once something starts to occur, some of those don't quite come into play. And so there may be some leeway in terms of that. So in terms of what the child was doing initially, I personally and may have issues with what was transpiring at that point. But then, and this is really the legal analysis, the defendant's behavior and what the defendant did begins to cross the line. And there are really 3 points at which it crosses the line. The first point at which it crosses the line is placing the child in that seat at all without some justification as to why that should be done.
This is the climax of the case. Judge Simpson walks through the legal framework step by step, and he makes 3 crucial findings. Placing the child in the restraint seat without policy justification. The manner in which the restraint was applied. 2 swinging motions that appeared non-defensive. The judge highlights that child safety statutes don't require injury, only risk. And by placing the child in a star seat unauthorized, the defendant created exactly that. Even if the child was difficult to manage, protocol prohibits improvising restraints. His focus on the swinging motions is important. Even without proving contact, the behavior itself signals aggression or frustration, further establishing risk. This is a textbook example of how judges balance protocol plus observed conduct plus legal definitions post final ruling. Viewers, do you think the judge made the correct call based on the 3 violations he identified?
This child could have been absolutely out of control. There's something else to do. You can't just decide, I'm going to basically strap a child down when the policy doesn't call for it. So that's the one thing. But then the manner in which the defendant went about implementing that violation of policy also causes a problem. There are 2 swings that I don't, in looking at the video, don't believe were defensive maneuvers on the defendant's part to block or stop something. One occurs as the child goes into the seat. There is a swing toward the child. There is then also one coming over the back. I can't say because there were angle that contact wasn't being, or that contact was made or that any harm, but to even raise your hand in that fashion and swing in that fashion is inappropriate. But really by virtue, so those are really the 3 points. By virtue of placing the child in the seat, the manner in which the child was placed in the seat, this court does believe that the people have sustained their burden of showing that the defendant did indeed violate the statute and did cause an unreasonable risk of harm to this minor child. And so for those reasons, the court would find that the defendant is guilty of child abuse in the 4th degree. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be August 9th, 2023, 9 a.m. That will be via Zoom. And ma'am, what I would suggest that you do is probation is right down the hallway. Stop there before you leave the building so that they can get you everything. Okay? Thank you, folks. Bond will continue.
Thank you.
14A stands adjourned.
Judge Simpson's conclusion reinforces what this entire case hinged upon. Not intent, not injury, but risk created through procedural violation. By restraining a special needs student mid-route and using questionable physical movements, the defendant stepped outside the strict boundaries of child safety protocol. The conviction, child abuse in the 4th degree, reflects Michigan law's emphasis on preventing harm rather than waiting for injury to occur. Probation referral and a pre-sentence investigation are standard steps, ensuring the court fully evaluates her background, behavior, and potential for rehabilitation before sentencing. This case highlights how crucial it is for school transportation staff to follow IEP instructions and established safety procedures. The line between managing a situation and creating legal liability can be razor thin, and in this instance, it was crossed 3 times. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.